With that, I would like to proceed with discussing at least the scheduling of the motion that was filed by the defense. I have a question as it relates to that, and is there any part of that motion that the state were to agree to? And I'll be very frank with that. Part of that motion, of course, deals with a change of venue, but there's an alternative that's being requested, and that is a jury from outside the county and sequestration. Those are two things that this county is not unfamiliar with. There is some precedent for getting a jury outside the county. That was in the Oswald case, and of course during one of the cases that we sometimes refer to as the Slender Man case, when one of those cases went to trial, that jury was sequestered. So I wanted to know if the state would agree to any of that, and maybe focus my attention on the motion otherwise.
That would be our alternative position, Your Honor. At this point, based on the filings that we've reviewed to date, we do intend to challenge the motion and ask the court to make a determination.
On all counts? Or is there any agreement that a jury from outside the county and or sequestration would be appropriate in this case?
Not based on the filings we've seen so far, Your Honor.
All right, thank you. Then that helps me as I address that motion and deal with scheduling. I would like to have the parties brief that. I do think it's important, though, if there were to be any conversations and discussion among the parties, if there were to be any agreement, I don't know if that would satisfy the defense at all. For example, if there were an agreement to get a jury outside the county and an agreement to sequestration, if that would matter to you as well. I'll leave that to the parties to discuss. As the parties, though, do their briefs on this topic, I do think it's important that the parties address the impact of Marsy's Law. That certainly is a relatively new constitutional amendment. To my understanding, I've done some research on the motion for change of venue. I don't believe there are any cases that would address that aspect, but I do think it's something this court must consider in the change of venue motion and the alternatives that are being requested. So I know the defense has filed more than a boilerplate motion. There's significant reasoning and basis for that, but that is just one piece I'm going to ask that you also look at and supplement with. The other question, though, is when is it appropriate to address that motion, right? I know the defense needed to file it by arraignment, and that's why it was filed. Is that something that the parties believe this court should address sooner rather than later, or only when we get to a point where a trial would be scheduled? State, have any thoughts on that?
Certainly the passage of time is one of the factors that the court should consider when weighing this motion, so I understand the logic in that, Your Honor. However, I think there is the ability for the court to move even pretrial proceedings to another county if the court felt that was appropriate. So for that reason, I would say sooner rather than later. Also, I think it's prudent to, I know you're going to want to hear about discovery, I know you're going to want to hear from the defense, but realistically, we're sitting here, it's March. I don't think there's any reasonable way we could try this case in November or December. So we're either talking about a trial date in October or in 2023. And I don't want to get too far ahead, but I think having that end date maybe help us work backwards to decide when this change of venue should be addressed.
All right, I appreciate those comments. Let me hear from the defense.
In terms of when to decide the change of venue motion, I think it should be addressed, in terms of if the court's ordering briefing today, I think that should be addressed sooner rather than later. The passage of time does show up a lot in the appellate decisions on change of venue. Of course, those are appeals after convictions when change of venue are denied. And so then it's a different assessment in terms of how did voir dire cure things. But I think just the procedural mechanism for this is it should be addressed kind of earlier on in the case.
All right, we need a little bit of break. More of this hearing when we return. Stay with us. Court TV Live, we're watching a pretrial motion hearing unfold in Wisconsin, Waukesha, Wisconsin, for the accused parade killer, Darrell Brooks. He's charged with killing 6 people and injuring dozens more when he drove an SUV through a Christmas parade last November. Prosecutors have not addressed any kind of a motive at this point. This morning, the judge is hearing arguments from the defense to move the trial to a different county or possibly bring in a jury from another county. The defense says that the publicity here has been so pervasive, something needs to be done in terms of a change of venue. Let's pick it up right where we left off.
I don't disagree with that. I also believe it does not preclude this court from putting the matter on the trial calendar and then backdating from there so that it can happen prudently and in due course. So with that, of course, when we have a trial is somewhat dependent on the review of all the discovery. I would imagine it's quite voluminous, so let's talk about that. Attorney Opper, is the state still collecting discovery? Do you have everything, and what have you turned over at this point?
Could I ask Attorney Basie to address this issue,
Yes,
please?
go ahead. Thank you.
All the paper discovery has been turned over. I believe that there are some videos I know videos have been turned over. We are going through the entire box of discovery on Tuesday to make sure that the defense has everything. I do believe they're missing some videos and some cell phone downloads. But in terms of the reports, I believe that they do have all the reports.
When would the state be in a position to try the case? I'm guessing, based on your comments, as soon as October.
Yes, we had identified a window of anywhere from the middle of September to the middle of October, Your Honor. That's still 6 months from now, and I believe Attorney Basie thinks all remaining discovery will be turned over next week, so that would still, again, be a six-month window.
And you've consulted with victims on that as well?
Not on that specific issue, Your Honor. Generally, we have talked about scheduling, and I think they understand the size of the case and the volume of the materials and things like that. So I have not specifically addressed with them this range of dates, but generally they understand this is a trial that will require significant preparation in advance.
I would note neither party's filed a speedy trial demand at this point.
Correct.
All right. Attorney Perry on that issue.
We are reviewing discovery as it comes in, but as you reasonably guessed, it's a lot. I think that if we're talking about October, that's probably fine. If we're past October, I think the earliest that we'd be available, just calendar-wise, we'd be looking at probably March of next year.
I forgot to ask a very important question, and that is, how long does the state anticipate this trial will take?
We're estimating 5 to 7 court days for the state's case in chief, Your Honor.
Have you thought about how long it might take to impanel a jury?
2 days?
So roughly 2 calendar weeks.
Yes.
If I add that, how long do you think the defense would need?
I don't know. I can't answer that at this moment.
any reason why setting aside maybe 6 weeks. I say that because my intent would be to do a trial from a Tuesday to a Friday, depending on, I thought about that in some other cases where I've done 2 weeks and I do a Tuesday through a Friday and I give the jury off on Monday. It's a little different if there's sequestration and then we have to be mindful and go all the way through. But at least a month is what I'm hearing. I realize that's not your case, but if I balance maybe what the defense may have, do you think that's reasonable?
I think, in my opinion, Judge, 6 weeks is excessive. 2 to 4 weeks is reasonable.
Anything else on that particular topic, Attorney Perry?
No, not this morning.
October is actually a really good month because I don't have any chief judge meetings that month that I would have to miss. So that would be a month I could target and could set aside here today. I agree with the state that 2 to 4 weeks, but to be on the safe side, I would block off the entire month of October.
As we approach the top of the hour, let's slip in a break here, and we'll pick up the rest of this hearing in Waukesha, Wisconsin when we return at the top of the hour.